So the last big main topic is statutory interpretation. And what we're looking at here is the role of the judges interpreting statutes, and that's why it's called statutory interpretation. In other words, really the job of a judge is to read an act of parliament and to interpret it. And the best way to think about this is like when you, in English, interpret poems and discuss what a poem would mean, like you would do when you did it at school. The concept is exactly the same. So judges get an act of parliament, they read it, they interpret it, and then they apply it to the case in front of them. Right? Now, it sounds quite straightforward, but what you've got to think is it can be quite difficult because words can change over time. It could be written in a way that could mean one of two or three different ways. It could be written quite vaguely. There could be words that are quite ambiguous. And you've just got to think of different types of words. And if I gave you a word, say for example, the word transport, if I said to you, write a list of everything that you would think would be transport, then your list may vary. So our language can be quite complicated, and also it means that it's quite a big job for judges to interpret acts of parliament, and sometimes can be quite difficult. So basically what we've got is we've got rules of interpretation, right? And there's four main rules of interpretation: the literal, golden, mischief and purposive. And ultimately it's up to a judge to decide which rule they decide to use, right? And there's kind of two philosophies or two types of judge. You've got a very traditional judge who does probably one of the first two, and that's the literal and golden. And basically their job is read it, interpret it, apply it. That's it. Sometimes this can lead to injustice though, and you have more kind of modern judges which are very much maybe less looking at exactly the words and looking more at the purpose, and those types of judges will use the mischief and the purposive approach. The key thing you've got to understand is this: a judge can decide which one they want, right? So if they read something, they might interpret it literally, take the literal approach, and that'll be the outcome. There is technically no right or wrong. It is very much up to a judge to decide which one that they use, right? So let's have a look at what differences are then. So starting off with the literal, right? Now the literal is probably exactly what you think it is, i.e. taking the words on that page literally, right? It's the eldest of the approaches, it's Victorian, and it is interpreting the words, their plain, ordinary, normal and grammatical meaning, right? And you could argue this is probably the easiest. So all a judge does is sit there, get the act, so say for example Theft Act, read the definition of a theft, and then apply it to the scenario, right? It is the most common used, it's the least controversial. Now when I say least controversial, it's least controversial because judges are doing their job. Let's go back right to the beginning. Judges' job is to interpret. It's not to make, it's not to construct, it's not to go, well, I think this, I think that. A judge's job is to get an act of parliament, read it, interpret, apply it to the defendant in front of them. So technically, this covers their job. And like I say, it's the least controversial because that is exactly what they're doing. And to be fair, it's most straightforward and most simple. Now the idea is that if a judge does this, they are following Parliament because they're reading the words that Parliament have written and applying it to the person in front of them. Right. One of the things that they use quite often with this is a dictionary, because obviously if it gets to a word, so it says it is illegal to be drunk in charge of a mode of transport, then they may look at the word dictionary to define the word transport, for example. The only issue is this, is that sometimes you can't take things literally, and sometimes if you take things literally it can lead to injustice, which the cases below show. Now if we're going to relate this to questions to do with the exam, the general type of question that would be asked is just describe the literal approach. Now it goes back to everything that we did in JP, so that is a D, FC structure. Right? So give a clear definition of literal. Features, remember. Anything else you remember about the literal approach. And then the key thing is cases. And you've really got to be careful with these cases. Now, for top marks, remember you're looking at for 4 cases. And then it goes down for 3, 2 and 1. Right? But again, remember, go back up to the top. If you just had definition and features, no cases at all. Your maximum you can get out is 4 out of 15, which ultimately is a fail. So, cases then. First case is a hinshi. Again, to make it simple, if you just want to remember one of the case names, that then makes it easier. Basically, this was an old guy. He had a little post office account, like a little bank account that were part of the post office, which he'd not used for quite a while and kind of forgot about. Now, what he did was he filled in his tax return form. And on your tax return form, you have to declare all your income, how much money you've got, all your bank accounts, etc, etc. Now, because he'd not used his post office account, he completely forgot he had it, so he didn't write it down on his form. And technically, you could argue that's filling in your tax return form incorrectly because he'd forgot about it. Now, the Finance Act that this law comes under said that basically anyone who failed to fill the form in incorrectly must pay treble the amount due. Right? Now, this judge decided to take the literal approach. So literally, did he fill it in wrong? Yes, he did. Right? And therefore, because he filled it in wrong, he had to pay 3 times the amount due. And again, some people can look at that harshly. It's not like he were filling it in incorrectly to kind of be corrupt or try and get out of it. It was just a mistake. But what they said was, I've applied it literally, I've read it, I've applied it to him, therefore, unfortunately, he's got to pay. Right? Now, excuse me. When we are looking at the principle, make sure you mention the word literally. Right? So give me the facts, but more importantly is this bit. Right? So in other words, literally, what did they do? Right? Second case, then we've got the case of Berryman. Now, this was a guy who got killed on the railway, right? And he didn't have a lookout man when he was working on the railway. Now, under the Fatal Accidents Act, it says that you have to have a lookout man provided if you are repairing or relaying the track, right? And if you didn't, you can get compensation. However, this particular guy was maintaining the line. So when his wife tried to argue that she should get compensation because there should have been a lookout man provided, they went, well, hold on a minute. I've got this law in front of me. I've read it. I've applied it literally. And literally, he was maintaining, not relaying or repairing. So, sorry, you can't get the compensation. Now, to most people, think, well, it's the same, surely. That's not what this rule is. It's about reading it, applying it literally. That's it. Now, Fisher versus Bell then, to do with selling knives in shops. Right? And basically, under the law, it says that it's an offence to sell or offer for sale a flick knife. Now, these knives were in the window of a shop. So, most normal people think, well, yeah, of course he's selling or offering the sale of a flick knife. Now, technically, under our contract law, if you put something in a window, it's only what is known as an invitation to treat. So it doesn't actually happen an offer for sale until you take it to the till, right? So, technically, or remember, literally, it was only an invitation to treat, not an offer for sale, so defendant got away with it, right? Again, it seems unjust, it seems stupid, because surely he were going to sell him because he put him in his window. But literally, if we apply it, that's how it works. And the last case, the case of Harris. This was a guy who bit off the victim's nose. And whatever offence he was charged with, if you look at the wording, it says it was an offence to cut, stab or wound a person using an instrument. Right? Now, again, literally, They said, it's not a cut, stab or a wound, and you didn't use an instrument. Therefore, literally you can get away with it. Even though we'd think it would be ridiculous that someone could get away with that. Right? So ultimately, it's simple, it's straightforward, the literal approach, but, and the big but, is that it's taking things literally can sometimes make ridiculous decisions, i.e. those ones that we've just seen. So the next rule then is, a lot of people like the golden rule because the golden rule solves the issues of the literal approach. And what that basically means is that if the literal approach leads to injustice, so like say for example you could say about like the case of Berryman, it were ridiculous that she didn't get the compensation just because it were maintaining, not relaying or repairing. A judge has the option of using what is known as the golden rule, right? So it's only used when the literal leads to injustice, right? So if we take the literal meaning, if that then we realise, oh, that leads to injustice, we then, if we want to, can use the golden rule and try and solve that injustice. But remember, judges don't have to do that, right? So any one of those judges in those literal cases that we've just looked at could, if they wanted to, use the golden rule, but they decided not to do that, right? And again, the trouble is, you're changing outcomes with the golden rule, so sometimes judges don't really like it. Now, there's two ways of doing this with the golden rule. You have the narrow application and the broad, right? Basically, what that means is if you take the literal approach and you realise there's a word that is meaning that it leads to injustice, sometimes that word might have more than one meaning. So you could just tweak the meaning of that word and hopefully it would solve that injustice. So that's a narrow approach. So we're just simply tweaking what a word means. However, sometimes it's not actually about a word that could be the issue. Maybe it's just simply that taking that literal approach has led to injustice and you don't want that to occur. So if that's the case, then we use a more broader application and say, right, the word is clear, we know it creates injustice, I'm going to take the golden rule and I'm just going to basically solve that injustice and change it. Again, you could argue that's a little bit controversial because you could argue, should judges have the right to do that? A good example of that is the case of Sigsworth. So Sigsworth was, he wanted to kill his mum to get all the money, right? So that's what he did, killed his mum. She didn't have a will, so basically it said that all the money should go to like the next of kin, which was her son. Problem is, her son was the one who killed her. So is it right that her son gets the money when he killed her? No, it's not. However, if the judge had taken the literal approach, the law is quite clear. The law is clear that he should get the money. However, the judge took the literal approach, realised that that led to an injustice of him getting the money, realised that it wasn't just about a word that needed tweaking, they just needed to change the outcome. So in this case, they used the broader application, right? So basically said, it's an injustice, we don't want it, we're basically changing it, i.e. you ain't getting the money. Right? So that's an application of not about tweaking a word, it's about just saying, do you know what? No, you're not getting it. An example of tweaking what words mean can be sometimes the confusing case of Allen. Now, to be fair, it was Parliament's fault this because they should have, it was the way that they worded the Act. But basically, the Act was in relation to bigamy. So basically in this country, bigamy, which is when you marry more than one person at the same time, is illegal, right? Now, this was a guy who had 2 wives at the same time. However, the way that the law was worded said that it was illegal to marry whilst already married. Now, the trouble is, that is technically impossible because you can't marry someone whilst already married because that second marriage legally never exists because you're already married. So it were a bit like a loophole. So what they should have done was word it saying it's illegal to go through a marriage ceremony whilst already married. Right? So technically, the way that it worded, anybody who'd taken the literal approach would get away with it because it's physically impossible to do. So what they realised, the Parliament realised the mistake, and the judges basically decided to just use the narrow application of the Golden Rule and tweak what the word marry meant. So the word marry means go through a marriage ceremony, and that means people can be guilty of bigamy, which is obviously the correct way of doing it. Right? Arda v George. Right, and again, this is like, it's just a stupid way of the way that they've written it. It's a loophole. Basically, under laws in relation to the army, it was illegal to obstruct the armed forces in the vicinity of a certain area. Now, in the vicinity generally means round. It doesn't mean in the area. So say, for example, this case related to people who were obstructing an army base, right? And basically the law says it's illegal to obstruct in the vicinity. So around the army base you can't obstruct the army, but technically the loophole is you can do it in the army base, because it doesn't say, the law doesn't say in and in the vicinity, it just says in the vicinity. So, ultimately, again, it's a loophole. So, if you took the literal rule, in the vicinity, it'd be around. Whereas what this case did, which again, is a better idea, is just basically say, look, in the vicinity, let's use the narrow application of the Golden Rule, and basically, in the vicinity means in the vicinity and also in it. Otherwise, it'd just be stupid. Now, like I said to you before, all those literal cases that we've just looked at, those judges could, if they wanted to, they could have used the Golden Rule, but they decided not to. And again, why do people decide not to? Well, it's just because they're traditional judges. Traditional judges don't like changing and tweaking. They believe their job is to interpret, and therefore they'll read it, interpret it, and apply the law. There's quite a few cases whereby you think, really, that judge should have used the Golden Rule. Duport Steele is a good example of that. And it just shows that, really, this judge should have taken the Golden Rule instead of the literal. So this was a case to do with trade unions, and when the trade union had written certain laws for this trade union, it actually worded it in the fact that the members could commit civil crimes without getting found guilty of it, which would be stupid. So again, it was just the way that they'd worded it, but they took it literally, and the trade union didn't get done for it, when ultimately they should have taken the Golden Rule. Now, the literal and the golden are very similar. So the literal and golden are about looking at what the words are and interpreting the words. Yeah, alright, the Golden Rule slightly tweaks it, but ultimately we are looking at the words and interpreting the words. Now, the mischeif rule and the purposive rule are a lot wider, a lot more flexible. And it's not just looking about the word, it's about asking yourself the question, right, what was Parliament's intention? Why did they make that law? Would they want to cover this person under this law? Now, the mischeif rule is only used very rarely. It's probably the rarest one out of all four. And the reason why is that it's only used when we've got two acts of Parliament. So in other words, we've got an act of Parliament on an area, that's then being redone into another one. And sometimes when that can happen, it can mean that we've got problem words from the old law to the new law. And if that's the case, then ultimately what we do is we use the mischeif rule, right? And the way that we do it is that we look at the old law, we look at the new law, we identify what the problem is, whether they've missed something or missed gaps or put a wrong word in, and then we ask ourselves the most important question with the mischeif rule is, what was Parliament's intention? Why did they create that law? And by asking ourselves that question, we then ultimately can decide the outcome of the case. Right? So, best way to think about this is the case examples again. So, Smith and Hughes then. Smith and Hughes were to do with the Street Offences Act, which basically covers the law on prostitution. And it says that it's an offence to solicit whilst on the street. Right? So, it's a criminal offence to be a prostitute on the street. This group of prostitutes basically were getting punters off the street, but they never actually physically stood on the street. They were in a window and a balcony. So if we took the literal approach with this case, literally are they soliciting on the street? No, they're not. So what's the problem word? The problem word is the word street. How do we solve this case? Well, we solve this case by saying, right, what would Parliament's intention be? Well, when Parliament made that law in 1959, the intention was to stop prostitution. And that's their intention. So by applying that, are they guilty? Yeah, they are. Very similar is the case of Corker versus Carpenter. This was to do with being drunk in charge of a bike. Now, under the particular law in relation to this, it's an offence to be found drunk in charge of a carriage. Now again, well, what do we include in the word carriage? Well, it can be quite a difficult question to ask. So we again go back to the idea of what's Parliament's intention. When they created that law, what was Parliament's intention? Well, it was Parliament's intention to stop people being drunk in charge of anything, really. So, should he be guilty of being charged with being drunk on a bike? Yeah, he should. Right. Next case, Royal College of Nursing. This was to do with the abortion law, 1967. When the abortion law was first created, the aim of the abortion law was to regulate abortions. So to make sure that somebody who was a registered medical practitioner did abortions not up back alleys like they used to do years ago. So that was really the idea of it. Originally, obviously, this meant doctors. Now, as medical advancements have come on, then really it should include nurses. So the question was, as the law's worded that an abortion should only be conducted by a registered medical practitioner, should that include nurses? Well, again, you've got to think outside the box. What was Parliament's intention? Why did they create it? Well, they created it to regulate abortions. So do we think that Parliament would allow nurses to do abortions? Yeah, we do, and therefore they were allowed. And then the last case then in relation to mischief is Eastbourne Council. Again, this is very similar to Smith versus Hughes in the aspect that the problem word is the word street. Now this was to do with taxi drivers. And basically, under different taxi driver law, we've got this aspect that you've got to have a licence. So in order to be a taxi driver and working on the street, you've got to have a licence. Now, when this taxi was pulled over for having no licence, it was technically on the forecourt of the taxi company. So, is it a taxi without a licence on the street? Literally, no it isn't. But again, we're being a bit more broader in this. We're kind of thinking, well, hold on a minute, what's the aim? Well, the aim is to make sure that we regulate taxis. Therefore, thinking about the aim, thinking about Parliament's intention, would Parliament want to get this person done for not having a licence? Yeah, they would. So it's a lot more flexible and it's a lot more broader. Right? Then the is the purposive approach. And again, it does exactly what it says. In other words, what's the purpose? What's the point? So the purposive approach is the complete opposite to the literal approach. So the literal approach is taking the word literally. Purposive is going, what's Parliament's intention? I don't care about the word. Would Parliament want this person to be guilty or not? Big issue with this is, well, how do you find out? How do you know? I always say you can't ring Parliament up and go, right, by the way, when you created that law in 1976, what were your intention? What did you want? So sometimes it is a bit more controversial because ultimately you're stabbing in the dark. Right? This is very modern. Right, so like I say, it's complete opposite to literal. Literal is old, it's Victorian, it's what we've always done. This is kind of the new guy on the scene, which is basically saying, look, we need to be more flexible. We can't just use the words anymore. the big main problem is finding out what Parliament's intention is. Right, we do have the option of extrinsic aids, which are things that could help us find out Parliament's intention. But ultimately, like I say, you can't ring them up and go, right, when you created the Theft Act in 1968, what were your intention? Because I always say probably most of them would be dead by now anyway. So, cases then. Case of Smith, first off. This was to do with a lad who wanted the details of his birth mum. The problem was the bloke who wanted the details was basically a psycho who'd already been convicted of 2 murders. He was already in prison, and basically there were quite a lot of strong evidence that he was going to try and track his natural birth mum down. He was going to escape from prison and he was going to kill her. Now, the adoption law is quite straightforward. When you reach the age of 18, you can get the details of your natural birth mum. So if we took the literal approach, we'll give this psycho these details. However, the court decided, thankfully, to take the purposive approach. Looking at the purposive approach, what would Parliament's intention be? Right? Parliament's intention would not be to give this person the details, and therefore they didn't. Right? So a lot of the time with the purposive approach, it's just a little bit more common sense. It's realising that our law and our words can't be as strict, and it's just a bit more flexible. Coltman versus Bibby Tankers then, this was to do with, it's very similar to Berryman in a way. It's about people being injured at work in a way. And this was a guy who was killed on a ship, and basically they said you can get compensation if you are using certain equipment. And they defined and gave a list what equipment meant, but specifically it didn't mention a word ship, right? Again, they thought about it in a broader way. They said, all right, literally, that law doesn't mention the word ship. However, under the purposive approach, would it be Parliament's intention to give this family compensation? Yeah, it would be. Probably one of the best examples is the case of Fitzpatrick. Fitzpatrick just shows how times change, words change. And what you've got to remember is this. That judge might be interpreting an act that's 100 years old. Well, 100 years ago to now is very, very different. And the law is very different. And Fitzpatrick's a very good example of that. Basically, it were a gay couple, 2 men who were living together. And they were renting this flat. Now, it was one of them who had the tenancy agreement in their name, right? And the other one didn't for whatever reason. Now, the one who had his name in the tenancy agreement died. Now, under the rent law, 1977, it says that if a tenant dies, then a family member can take over it, right? So can continue to live there, take over the tenancy. If you took the literal approach, is his partner a family member? No. So not only has he lost his partner, he'll now get thrown out of his house. However, what they did was they used the purposive approach. Would Parliament's intention be to include relationships under that term family? Yeah, they would, and therefore it could continue the tenancy agreement. And then the last one is Cutter versus Eagle Star. Again, a good example. We have a lot of cases that really have an issue with the word road or street. I mean, technically they're not on the street or technically not on the road. And this is another good example. It was to do with Road Traffic Act. And the Road Traffic Act said that if a person gets injured and sustains injury from a car whilst on the road, they can get compensation. Now, technically, this were a person who got injured in a private car park. So, literally, is it a road that he got injured on? No, it's not. It's a car park. Again, let's think about it more logically. What would Parliament's intention be? Parliament's intention would be to give him the compensation. Therefore, he got it.